restrictions on industry, in the case of CALIA on the telecoms. In the case of the programs I'm going to be talking about, more than $2 billion by the DHS own gross underestimate of mandated modifications to travel industry IT systems in order to support performing these government surveillance and control functions. Finally, these systems have in common that they are suspicionless dragnets, not limited to suspects or people who are being particularly investigated, but collecting information about everybody in case it might later be of interest to the government. But although travel is not sui generis in the way the government says, there are still significant differences. One is in the legal framework, in which oddly, at least in statute law, communications and the movement of our messages currently has more legal protection than information about the movements of our physical bodies. That seems weird, but that's the way it is. Congress doesn't seem inclined to fix it. The second big difference, perhaps bigger difference, is in how the government uses this data. This is not merely a panopticon of surveillance, but an active real-time control system. It's a bit confusing, and this is going to be a bit technical, and I will grant that everything I'm going to say from now on is a gross oversimplification. Otherwise, we'd be here for days or weeks. Travel IT is complex and technical, and DHS has confused the matters by its own inconsistency of policy and language over the last decade as the system has evolved. There are three different sets of not entirely identical but overlapping data that the government has required airlines and travel companies to collect and make available to the government, depending on whether it's an international or a domestic flight with different names. There are also different systems with different names: secure flight for domestic travel, the automated targeting system for international travel. There's also a difference that probably isn't as significant as it looks, which is in the case of international travel, DHS actually makes its own mirror copy of the reservation information, whereas for domestic travel, it merely maintains real-time access. But again, that doesn't matter so much. All of the controls on privacy of this information that the government has talked about are controls on its copy, which are meaningless as long as it can go back to the industrial host of the data and get another copy whenever it wants. So who's holding the copy really doesn't matter as long as the government has root access, which it does. The people who designed these systems at DHS, who mostly came from NSA-type backgrounds and knew nothing about the travel industry, assumed after 9/11 to be really easy, they would simply get the information that the airlines have about travelers and make their own use of it. But it doesn't really work like that, because most airlines outsource the hosting of their reservations to companies called computerized reservation systems or global distribution systems, which also serve other travel companies, hotels, travel agencies, and so forth and so on. There are four major and one more recent and as yet minor, Google, which spent $700 million 2 years ago to get into this business, which gives you a sense of how significant a business it is, which together form, in a sense, a outsourced global cloud for hosting of reservation data on behalf of the entire travel industry. If you look at this diagram, you'll notice a couple of significant things. One is that there are typically at least two intermediaries between the traveler and the government. This is why the government can get this data from the travel companies without needing a warrant, because under the third-party doctrine, it's considered their property in which the traveler has no right. The traveler doesn't necessarily even have any way to know whether the government has gotten this data. But of course, being a global cloud, each node in the cloud is a point of vulnerability. Vulnerability to exploitation of this data by marketers and data miners who may be completely unknown and invisible to the traveler, by criminals, from hackers to terrorists, and by government agencies, not merely DHS, but other law enforcement in the US and foreign governments and their law enforcement agencies around the world. Now, in Europe, there's been a great deal of concern that, as this diagram example shows, someone traveling within Europe on a European airline making their reservations through a European travel agency, even when the master copy of the reservations is stored in Europe, there still may be multiple mirror copies in the cloud in the US, which DHS can access here without anybody in Europe, even the airline, knowing about it. And if you say, well, so what about Europeans? The converse holds true as well. Even if you're traveling within the US, pick your bogeyman, any government in the world where either the airline or the reservation system or the travel agency has an office can get access to it. For example, the Chinese Public Security Bureau can go to the United Airlines office in Beijing and ask them to call up your reservation from Washington to Chicago. And they can do that, and they're required to because they're Chinese citizens subject to Chinese jurisdiction and law. And they can hand that over to the Public Security Bureau in toto. No record is kept of this by the reservation system. It is not visible even to the airline that this has happened, and unless you or somebody you know happens to be looking over your boarding pass until they've received that individualized per-flight, per-passenger message from the government. Now, you might think that if they're stopping you from flying, that might implicate the law. Indeed, it does. TSA is fond of saying you have no right of travel by any specific means. That contradicts express statutory language, not only guaranteeing your right to travel, but specifically guaranteeing your right to travel by air, and specifically obligating TSA in its operations and rulemaking to consider that right, as they never have done in any rulemaking to date. Now, if they're not following the law, can we get it reviewed in court? Ginger will be talking a bit more about that one later, but it's also interesting to look at what the express policy of the DHS has been. These statements are from speeches by former Secretary of Homeland Security Chertoff, who repeatedly said that he did not believe that no-fly orders should be subject to judicial review, which is a remarkable statement from a former federal judge saying that he thought his decisions as DHS secretary should not be subject to review by the kind of person he used to be back when he was a federal judge. And while these are policies of DHS under the Bush administration, no Obama administration official has repudiated these views, and indeed it continues to be DHS practice, not so much to defend the systems that I'm talking about here, but to actively resist being obligated to defend them before any court at all. So what is in the records that they compile? Your lifetime travel history. If you've traveled across U.S. borders in the last 10 years, DHS has a file on you. With the Identity Project, we've put out forms for people to use. You can find them on our website at papersplease.org or on my website. We've been compiling the responses. Eventually, I sued for the portions they had withheld. After stalling me for 3 years, CBP retroactively exempted the automated targeting system records from the Privacy Act, and the district court upheld the retroactive application of that exemption. But they did, in their discretion, release quite a bit of self-damning information. Some of the information that we know is there and have seen, and I'll show you examples, include complete copies of PNRs, passenger name records. These are airline reservations, but they also include non-airline data. An index, a log of every time you've crossed the border by any means, and free text notes attached to that that give more information about whatever they deemed of interest. This is a very simple passenger name record for a flight, as it happens, from Washington Dulles to Ezeiza Airport in Buenos Aires. What's interesting here is some of the kind of associational data. The only contact information for me in this reservation is the phone number of a friend that I gave when I reconfirmed my flight, who was intrigued and somewhat surprised to know that he'd been permanently linked with me in our Homeland Security files. This is another simple reservation for a flight from Montreal to San Francisco. Here we see, down here on the left side, this is an IP address and a timestamp. So that can be correlated with whatever other internet records might be associated with this. Of course, there's also the email address, the credit card number, permitting them to pull in a lot of other associational data. These are wonders for the government for social network analysis, and in fact, that's what they talk about using them for, to find people who are not yet suspected. This is deliberately a guilt by association machine. That's what it's designed for, and that's how it's used. It's not limited to air travel or travel to and from the U.S. This is a trip I took to Brussels. Lines 3 and 4 in this reservation reflect the portion of that trip from Paris to Brussels and back by train. What's that doing here in a permanent DHS file? This one, similar, this is a trip to Strasbourg, France. Line 4 is a ride on the Lufthansa highway bus from Strasbourg to Frankfurt. Here, this particular PNR extract is the smoking gun that showed that DHS has route access. They're not merely using an airline user ID. They have their own user IDs with route privileges. This person traveled to Berlin, stayed there for a week, then traveled on via Prague to London, stayed there for a week, then came home. Lines 3 and 4 are a journey entirely within Europe. It was the rest of the PNR, which I cut out here to show you this, shows that this was a separately issued ticket, not connecting to or from a flight to the US on an airline that doesn't fly to the US. United Airlines, if you called up the reservations to Berlin, would not have seen that. Only a user with route privileges would have been able to retrieve that, as DHS did. Everybody who I've spoken with who's gotten their file from DHS and brought it to me and said, what does this mean? When I've gone over it with them, there's been something that surprised and disturbed them in their file. Most of the time, once they've seen that, they don't want me to put their file on the internet. But each of these things here are something that I have seen in actual examples of files that people have received in response to their requests. And remember, this is just the stuff which, in its discretion, DHS chose to tell us. Hotel reservations, if they're made, whether or not they show up is a complex question, but they sometimes do if they're made in the same reservation with the flights. And I've seen in them, in a reservation for multiple people, linked together with their name, their gender, their age, date of birth, and so forth, the code showing behind the closed doors of their hotel room whether those two travelers asked for one bed or two, in their permanent lifetime file accessible to the government wherever. Special meal requests, which may show religion, a special service request, which may show invisible medical conditions. These show up routinely. Reservations for tours or cruises. Again, the nature of the tour, or the tour operator, the demographic, there's a lot of other information that may be more revealing than you think in these kinds of services. Billing codes are routine. For example, law firms routinely have their travel agents enter in their PNRs what client they're billing the trip to. Again, this is everything that the travel company captures for its business purposes. It's just hoovered up wholesale by DHS into your permanent file. There can also be discount codes. For example, if you get a discount because you're part of a group that's traveling to a particular conference or event or convention, that billing code may reveal what organization's convention you were attending. Even if it's an organization that is normally very resistant to disclosing its membership lists, as many are. The second component of these files, in addition to the reservations, is the entry-exit log. This is an excerpt from mine, showing entries back to 1992, even though the notice that was supposed to be published in the Federal Register before this system came into operation wouldn't be published till 14 years later in 2006. Operation of a system of records without a proper notice is a crime nobody's ever been prosecuted for. Funny thing. This information is not just limited to flights to and from the US. It also includes overflights of the US. This is a great concern, for example, to Canadians who, if they go on vacation in Cuba, inevitably overfly the US. So the US has access to a list of all the people who've flown to Cuba on their vacations from Canada. And if you say, well, I don't care about that, what about the reverse? Imagine the reciprocal. What would happen if Cuba were to say, and I've routinely been in Cuban airspace on American Airlines flights between Miami and pretty much anywhere in South America. What if Cuba were to say not only that they want the passenger manifests and all the information that the airline has on everybody on any of these flights, but that the Cuban government is going to vet them in advance and nobody gets on one of these planes on American Airlines unless the Cuban government approve? What would we think of that? That's what the US government is now demanding of other countries. Again, it's not limited to air travel. This is a log entry 2V, is the code in airline systems for Amtrak. This is a trip I took by train across the US-Canadian border between Montreal and New York. Here's one for a trip by private car. More recently, the CBP has installed license plate readers at the border crossing, so a more recent comparable entry would also include the license number of the car that I was riding in. And then finally, there's the free text notes that can be associated with any of the entries in this log. And these are not just people who were arrested or suspected. These can be entered even when nothing was found. Negative computer queries for criminality wants and warrants, negative vehicle exam, subject is a US citizen. In this case, this was somebody who walked across the border. Why is this recorded in their permanent file? For what conceivable purpose and use? This is one of my files. I flew back from, well, I won't say, but I connected through London and had an apple and some bread when I got to customs. And I said, can I keep these? And they said, you can keep the bread, but the apple's fruit, so you have to throw it away. I threw it away and thought nothing of it. Some years later, I find in my file that I'm permanently linked to this event. On another occasion, I had been at an agricultural industry expo in Buenos Aires. It's a major industry there. And I checked the box, as you're supposed to, that says, I've been around livestock. So you may not know that what happens when you check that box is that in thoroughly biblical sense, the Customs and Border Protection people get down at your feet at 5 o'clock in the morning in Miami when they've just come on shift and wash your shoes with disinfectant. Well, okay, if they get off on washing my shoes, they get off on washing my shoes. But why does this belong in my permanent file? This is actually from John Gilmore's file. He had a book entitled Drugs and Your Rights. Again, if this is not prohibited recording of the exercise of First Amendment rights, I don't know what is. Again, from another trip that John Gilmore had taken, passenger was traveling for about 1 month. Passenger attended computer conference in Berlin and then traveled around to visit friends. 100% baggage exam negative. Passenger is self-employed, quote, entrepreneur, close quote, in computer software business. I guess being an entrepreneur is a suspicious fact that belongs in your permanent file. There's more to all of this. I hope that all of you will be inspired by this to look into what is in your file, but also to look more closely at the reality of how that is being used and what we need to get out of the situation we've been put into, where we now travel by common carrier only as a privilege granted by permission of the government. Thank you.
Now you have some that Ginger McCall lacks the intensity of Edward Hasbrook, but she has all the doggedness and maybe more. She's the director of the Electronic Privacy Information Center's Open Government Program. She teaches on the law of open government at the Georgetown Law Center. She's working on a variety of issues at EPIC, including consumer protection, open government requests, amicus curiae briefs, and national security matters. She litigates EPIC's Freedom of Information Act lawsuits and is a co-editor of Litigation Under the Federal Government Laws 2010. Ginger McCall has co-authored several amicus curiae briefs on privacy issues to the Supreme Court, and she regularly speaks on privacy and open government issues. The number of forums at which she's done so is many. Hopefully she'll add to her resume the fact she's now spoken at Cato. She's, of course, provided commentary to numerous outlets and journals to discuss the TSA's recent rulemaking, to the extent there is one, in the strip search machine policy. Ginger McCall from EPIC.
Thank you very much for having me. I'll try to give as much intensity as I can give to this. Jim's staff was helpful enough to give me some coffee beforehand, so hopefully that will add to it. So I guess I'll start off with the good news. Right now we have a very unique opportunity to comment on a very controversial air travel program. The body scanner program, as we're calling it at EPIC now, nude body scanners, have been something that EPIC has worked on for 4 or 5 years now. We have had several lawsuits on this topic, and finally it's come to fruition with an actual notice and comment rulemaking period by the agency. Now, skeptics among you will probably ask, what would be the point of a notice and comment rulemaking period? Isn't the agency going to just go ahead and do what it wants to do anyway? But we really do believe that this is an opportunity for the American public to weigh in on this. And if the agency doesn't take your comments into account, doesn't take our comments into account, we are willing to go ahead and take this further in court. This notice and comment rulemaking actually came out of a lawsuit that we filed on July 15th, 2011. And this was a lawsuit in DC Circuit Court. We filed under several legal doctrines, including the Fourth Amendment, the Privacy Act, and the Administrative Procedure Act. Now, that Administrative Procedure Act says that if an agency is going to issue a new rule, it has to go through a notice and comment rulemaking period. It has to actually solicit the comment of the American public. It has to give you and the rest of the American public and everyone who cares the opportunity to comment on that rule and give the agency feedback. And the agency is supposed to take that feedback into account. So we filed, we had asked the agency we petitioned the agency for this rulemaking multiple times, and finally we got frustrated and we filed this lawsuit in court. And the court actually ruled in our favor on the APA issue, which is quite unusual, and it was a result that we were very pleased with. The court found that, quote, the TSA has not justified its failure to issue notice and solicit comments, and the court also said that the agency practice, these body scanner machines, the nude body scanner machines that show that naked image to the TSA officials, imposed a substantial burden on the public. According to the court, quote, few, if any, regulatory procedures impose directly and significantly upon so many members of the public. Millions of travelers going each day through these airports, passing through these body scanner machines that were at that point posting up this graphic image for some TSA agent in a room to look at. And the court expressed concern about the agency's use of body scanners. It ruled against us on the Fourth Amendment issue, but this was largely based on the agency's representation that members of the public had the option to, quote, opt out of the machines, that you could opt for a pat-down. Now, when we had originally started pursuing this topic, that pat-down was just a fairly typical pat-down that you would expect. However, after we started to pursue this more doggedly, I suppose the agency started to get a bit frustrated and started to issue what were called enhanced pat-downs. Some of you might be familiar with the sort of libertarian campaign that happened in the wake of these enhanced pat-downs, the "Don't Touch My Junk" guy. If you're not familiar, I definitely encourage you to YouTube it and to do a little bit of research on what's included in these enhanced pat-downs. Now, these enhanced pat-downs, this is not an option that Epic would ever stand behind. We focused mainly on the body scanner issue and on the option for passengers to opt out. But that doesn't mean that we think the enhanced pat-downs are appropriate. In fact, in our own comments to the agency, we're going to ask for a very different alternative. But the court ordered the agency, in this case, to undergo that notice and comment rulemaking. And the court said to the agency, you need to do this, quote, promptly. The agency interpreted this as, well, let's see, it was a nearly 2-year delay. And during this period, Epic filed multiple times with the court to, encourage the court to tell the agency it needed to follow up, to give the agency a 30-day deadline, to give the agency some sort of deadline by which it needed to issue this notice and comment rulemaking. And approximately, I guess, 20 months later, now here we are finally looking at the rulemaking. After the court set a deadline last fall for the agency to have this completed by the end of March. So on March 26th, which is no surprise to those of us who are following this, actually, I figured it would be later. I thought that it would be the final Friday in March at 4:30 p.m. But they did it a few days early. They got it in under the wire, March 26th. The TSA started its notice and comment rulemaking period. So you, the members of the public, and we at Epic, and anyone else, the organizations here, Cato and others, can now comment on this. The deadline for filing is June 24th. We have information up on our website on epic.org. You can look, it's in the upper right-hand corner of our website, or you can look for the key term TSA comment. You can also use the tiny URL that Jim has mentioned, and we certainly encourage you to comment on this. Now, we've taken a look at this proposed rule, which really amounts to 2 sentences. And the two sentences the TSA is proposing to use to modify its current screening procedures are, and here I'm going to go ahead and read it for you. The screening and inspection described may include the use of advanced imaging technology. For purposes of this section, advanced imaging technology is defined as screening technology used to detect concealed anomalies without requiring physical contact with the individual being screened. That's it. That's 20 months worth of work right there. So Nowhere in this does it take into account really the invasiveness of these machines. Nowhere does it take into account the fact that your only alternative to these machines is a super invasive pat-down. Nowhere do they take into account the sorts of real costs to passengers who choose to opt out of this and are then subject to long waits. I've attempted to opt out personally on this, and I ended up having to opt back in because I waited for about 20 minutes for a TSA officer of my same sex to come and give me an enhanced pat-down. And finally, when I decided that I was going to miss my flight to the conference I was going to, I was forced to opt back in. And this comports with a lot of what we heard from travelers when we asked travelers to tell us what their experience at airports had been. And it comports with a lot of what we found when we made a Freedom of Information Act request to the agency. We had requested originally back in, I believe it was 2008 or 2009, several different sets of documents from the TSA on these body scanners, and this is part of what inspired our entire campaign against the TSA. We requested documents like contracts, statements of work, technical specifications for these machines, as well as passenger complaints. And what we got back was a stack of passenger complaints that was probably about this high. And we also got back contracts and statements of work, which you can find on our website. And these indicated that the TSA wasn't really telling the truth about these devices. It wasn't really telling the truth about what the devices were capable of. They indicated that the devices were not designed to pick up powdered explosives, which is something I'll talk about a little later in context of the rulemaking. That the devices were capable of capturing, storing, and transferring those underlying graphic naked images that were produced by the body scanner machines. And there were several other interesting findings that we had there. I won't spend all of my time now on that, but you can find that information up on our website. And this is part of what inspired our later lawsuit about the rulemaking, is we really thought that this was quite a large step for the agency to be taking without ever actually opening up to comment from the public. So, given the text of that proposed rule, which again you can find a lot of information about this on our website and also at the tiny URL that Jim has mentioned, we have some recommendations. And these are the recommendations that we were planning to include in our comments. And we also have some places where we think that it might be great for other people who have complementary expertise to weigh in. First, the agency has completely taken over the dialogue on this. First, it was the use of the word whole body scanners. Okay, so it was whole body imaging originally. So whole body imaging machines. But I guess TSA decided that that wasn't a nice, warm and fuzzy enough term, and perhaps it gave the American public a little bit too much of an idea of what was going on with these machines. So they changed the term to body scanners. And now they've changed it to an even more sanitized term, which is advanced imaging technology. We're pushing back on this. We would encourage you to do the same. I know some people have slightly more extreme versions of this, porno scanners, etc. We've taken to calling them now nude body scanners, or NBS, because it gives a much more accurate description of what the machines are actually capable of. We plan to support what's called Regulatory Alternative 3. In these comments, the agency summarizes several different alternatives. And one of those alternatives is just to leave things the way that they are. To stick with the metal detectors, as we have been doing for the last, probably, I don't know, 2 decades, decade and a half. And another alternative is to focus on the use of metal detectors along with explosives detection technology. And that's something that we would endorse because it's much more narrowly tailored. It's only looking for a particular thing, and that thing is the threat. Whereas the body scanners pick up all manner of medical devices. They pick up anything extra that you might have in your pocket. And in fact, as we discovered when we issued our Freedom of Information Act request to the agency, they are not designed to pick up the very powdered explosives that are the key threat right now. That is the PETN. And we also are very heavily going to come out in favor of the passenger's right to opt out. And to demand the use of generic image filters. One of the things that the agency did that I think this was somewhat of a victory to Epic and to Cato and to others who've worked on this issue for a long time is that they did make some modifications to the machines in light of public protest against them. They required that privacy filters be put on these machines. But what we're asking is that those privacy filters be mandated. And in fact, Congress has asked for that same thing. They've mandated that TSA use generic image filters on individuals that go through the screening process. And the courts have actually relied on the fact, in ruling against us on that Fourth Amendment claim, they relied on the fact that the agency has represented to them and has represented to the public, you have the ability to opt out. So we're saying in this rule, let's go ahead and just put that into the actual regulation itself, that you passengers have a right to opt out, and that the agency must use these generic image filters. There must be no underlying graphic image. There must be no other image that could possibly be stored. The image that is just the generic stick outline that has a spot on it that highlights where the anomaly is, that must be the only image that's produced by the machines. And we're encouraging the public and any other organizations, especially membership organizations, to have people submit their personal experiences with TSA. That stack of complaints that we got showed a lot about what the agency has actually been doing on the ground. There's always discussions here in Washington about the reality in the ideal case, but very little actual discussion about the reality on the ground. And the reality on the ground is very different in airports around the country. The agency represented, and we saw when this controversy really started to pick up, that they put into place in the DC airports, where members of Congress would be going through the airport, really great signage about the body scanner machines, and you have the right to opt out, big television screens explaining to you what these body scanner machines are and that you have the right to opt out. Everywhere else in the country you got a piece of paper that was about this big, and it was usually about 25 feet away from the machine, or it was right in front of the machine so that it was already too late for you to really exercise that option. And that was the best case scenario, is that you actually got that piece of paper that told you, this is a body scanner machine. In some places, there wasn't even that. So again,